Welcome to the second edition of the Menterprise Talks with Ms. Hilda Wamono. We are thrilled to have you join us for a session of insights, practical guidance, and inspiration for innovators and entrepreneurs. As Menterprise, our goal is to create a space where ideas meet action, and we do this by helping creators, builders, founders gain the knowledge they need to protect and grow their projects. Today's session specifically focuses on an area that's essential for anyone who wants to safeguard their creations. So we encourage you to engage actively, ask questions, take notes, and think about how the lessons shared today can apply to your own ventures. It's my pleasure to introduce today's speaker, Hilda Wamono. She's a Ugandan lawyer dedicated to raising practical IP awareness across Africa. As the founder of IP Aware Africa, she focuses on empowering underserved creators and innovators, especially youth and women, with the knowledge and necessary tools to protect and benefit from their ideas. Please join me in giving a warm welcome to Hilda Wamono. Hilda, you're welcome.
Thank you. Good morning, everyone. Yes, I think Daisy has given a very good introduction of me, so I think we'll go straight to the session. We are here to basically understand intellectual property in regards to the creations and innovations that are created by tech innovators or anyone who is into creativity and innovation. We are not going to go into the legalities, the processes, and all that. We will basically look at the different IP aspects applicable to tech innovators. For example, we're going to look at copyrights, we are going to look at patents, we are going to look at trademarks, we will look at trade secrets and industrial designs for today, because those are the most applicable IP aspects in relation to tech innovators. So basically, IP refers to valuable creations of the human mind. IP aspects or anything created or innovated is not taught to anyone that, you know what, let us, you're going to do this and this and this and then you create something. No. Most of the time, it is just conceived by the human mind, like an idea, and then you bring that thing to life. That is IP. That is either the patent or the copyright or the trade secret that you create at the end of the day after conceiving that idea that you came up with. We are going to look at the examples of each. We will look at the common challenges or common pitfalls among the tech innovators. We will also look at the importances of embracing each IP and the benefits. And then we'll look at the protection, but not the procedures of the protection of the different kinds of IPs that we are going to look at. So let us start with copyrights as an IP aspect relevant to tech innovators. So copyrights are literal, artistic, and scientific works. Examples of the scientific works we have in copyrights for tech innovators, for example, you guys do software coding, you guys create apps, the UEI, is it UI, UX designs, the user manuals that you guys provide to the different consumers of your products, the structured digital data sets, among others. Those are the examples of copyrights. These new technology advancements are affecting the creations of innovators. For example, you'll find an instance where an AI is copying a copyright, like a copyrightable work. Or you're going to find an AI replicating the work of a creator or an innovator. Or they're going to use it to train, they're going to use that work, that copyrightable work of yours to train their AIs. You get it? So it's better most of the time to protect it by registering. That's what I would recommend. Let us look at the common pitfalls or common challenges, or the things that tech innovators do negligently in line with their copyrights. So most of the time that you assume that when you're creating or you're innovating, you assume that the kind of work you've created, whether artistic, whether literal, whether scientific, it is protected. Like your idea, like you sit and then you come up with an idea, and then you feel like your idea is protected. Copyright does not protect the ideas that you come up, like, I'm going to maybe create some software code, you just mention it, and you're like, oh, that thing is protected, No, copyright does not work like that. So when you express that thing, when you put it into writing, after you conceiving the idea and then you create that thing, that's when it amounts to copyright. But otherwise, the idea in you is not copyright. But what you create is what amounts to copyright. And that is what is protected, not your idea in the head, not. Then, most of the time, you are negligent in trying to protect your ideas. Honestly speaking, just like the law says, all copyrights are automatically protected when you create them. But however, the kind of creations or the kind of innovations in tech are not ordinary copyrights. So you do not neglect or you do not be ignorant about formalizing the registration. You make sure that you register them so that they're protected. Then the other thing is that you neglect the source code. You guys, after creating code, all those technical things that you call in your innovation field, you just neglect those creations like that. You don't protect them because I know the systems of protecting that code. So you just leave them bare like that for anyone to copy, for anyone to manipulate, for anyone to do anything with them. You're weakening the kind of creations that you're making. Then the other thing is that, for example, sometimes you have the people who are creating or who are innovating are just employees, So most of the time when these people create things, under you, maybe you're a founder, you are an employer, there is someone who is creating or innovating that particular product, that particular copyright, you do not define who is the owner of the copyright or who is the owner of that IP that person has created. So it brings about disputes later on, who is owning this, who is supposed to benefit from this, all that becomes a challenge. The other challenge is that you're negligent in enforcing your rights. For example, when there is infringement, you do not go after or you do not want to, find out what your rights are. How much did this person infringe on your copyright? You do not consider that. Since you've left everything bare, people just go on rampantly using your work without being held accountable or liable for their deeds, which is wrong. Then, in commercializing IP or your copyright, you also don't explore licensing. For example, you want to use the thing on your own, you want to use that product that you've created on your own. You do not want others to maybe use or explore it, to see its importance, to see how far, maybe to make improvements on it. All those things, you do not explore them. You keep the product within you or within yourselves. Then let us look at the registration or benefits of registering or protecting your copyright. Yeah, I just said once again, however much all copyrights are automatically protected, but when you register your copyrights in that particular product, you have stronger evidence of ownership. In cases of infringement, maybe you're before court, it is easier for court to consider that you're the real owner, you're the rightful owner of the copyright. So it gives you stronger evidence, and you're also recognized as the owner of the copyright. Then it also helps secure full economic value. What does this mean? For example, when you have I assume when you have something maybe a copyright. By the one thing I maybe not mention at the start is that IPs are like any other kind of property, So when you create this thing, I assume you want to, make money over it. So when you're the rightful owner of something, you are free to exploit it in any way commercially. So it enhances the what? The economic value of the product that you're trying to make or that you've made. Then yes, it enhances compensation in infringement and then commercialization. For example, of course, like for example, when you infringed on a, like when there is someone who has infringed on that copyright, what happens most of the time is that since you're the rightful owner, or since you've argued your case and then court has found out that you're the rightful owner, trust me, you're going to be properly compensated for the infringing activities of the person who infringed on your product. Then also, when you register your products, when you register your copyrights in an IP, in your tech innovation, you automatically gain, recognition and credibility for what? For creating that particular copyright. You know very many people who have created the software code and all those things. They are known that they created some particular IP product. Then we'll go to the second aspect of IP for tech innovators, which is trademarks. Trademarks are basically a sign or mark or a combination of a sign or mark capable of being represented graphically to distinguish your product or service from that of another. So it can be a mark or a sign, or a combination of a sign or mark, but capable of distinguishing your product or service from that of another. What does this mean? I presume again that when you're innovating or when you're creating a product, you are like setting up a business, or you one time plan to set up a business. So it is very important that when you're starting, this journey of innovating or creating, you have that aspect of exploring trademarks. Trademarks are, it's a tool used in business most of the time. For example, it may be a word, a symbol, a slogan, a logo, a sound, or whatever. Name all those. For example, a word, I could use an example of the host institution, which is with us here, Menterprise Africa. You have the Menterprise Africa word. That is a word. That is a trademark. You have a slogan, for example, you've had Mountain Dew adverts, like for example, is it do the dew, feel the dew, something like that. That is a trademark. You've seen logos. You've seen the Mukwano Industries, Mukwano Company and Industries, or Mukwano Industries. Yes, you've seen the handshake. Yeah, that is a logo. You've seen the logo of Mercedes-Benz, that triangular thing. You've seen the beaten up of iPhone. Yeah, those are literally signs or marks that are trying to differentiate someone's business from that of another. The word of Menterprise Africa, I'm seeing something like circular, Yes, that is a logo. You've had sound like, for example, a Nokia sound, like that famous Nokia phone sound, like when you're powering it on. Yeah, there are some trademarks which are smells also. For example, perfume brands, it is particularly attached to that company or product, So all those are the different kinds of trademarks. What are the common pitfalls? Again, the common challenges or the common things that you guys, who are innovating in tech overlook, Like any other business, tech innovators assume that the company name they have is their trademark. Since it is a business, you assume that whenever you register a company, the moment you register your company, that company name is your trademark. No, that is just a name. It is not your trademark. If you've not registered it as a trademark, it is not a trademark. It just means a company name showing that, Menterprise Africa exists. I'm going to take I'll take an example. For example, like we have seen that Menterprise has a name, Menterprise Africa. We have seen that it has a logo, that circular thing. Now, if that circular thing on your name is not registered, trust me, you're just having, I don't even know how I should describe it, but someone else can, take away that thing because it is not registered. You just have a company called Menterprise Africa, not a trademark. Yeah, and also when I was checking the startups link that Daisy sent me, I saw like a whole list of different tech innovators here, like with the logos on the websites and what have you. So I don't know whether those are registered or they're just like, Then, when you're also starting your business most of the time as a tech innovator, you do not bother to conduct a comprehensive search. Again, I'm going to use that example of the different, like the startups that were on the link of the Innovation Hub. I don't know whether those guys conducted a search, like a comprehensive search, maybe like visiting the URSB or internationally, like, to know whether such, like, this word or the logo exists somewhere else. I don't know whether they noted that, or they're just merely conducting internet searches and also maybe admiring, like how a particular name appears, how a certain, symbol appears that, they just copied and, they started doing their work. So it's very important for you to conduct comprehensive searches, both in the registry and also internationally most of the time. Then you also most of the time use generic, logos. You use generic trademarks for your businesses. For example, you could have like, a particular founder or a particular business doing something, maybe a tech innovation related to computer, and then they have something computer related as a trademark. It is not advisable because it is generic. It is relating to the kind of product that business or that founder is doing, so it is not allowed. So it's better most of the time to conduct a comprehensive search, to also inquire, which most people don't do. They just come up with their own things and then they paste them on the website. They start creating websites and what have you. So you end up with things that are generic or descriptive. This may not be necessarily in tech innovation, but for example, let us take an example like you find someone like selling apples, but they have an apple as a trademark. It is not allowed. That becomes descriptive of what that founder or that business is doing. So it is not allowed. So it's very good for someone to inquire, or the tech innovator to inquire, like, what is supposed to be a trademark. Then the other challenge is you assume that when you, again, I'm going to continue using the examples on the website or on that link that I was sent to, which has all startups in the hub here, the Ministry of ICT. You think that when you come up with that trademark that is on your website, like for example, Menterprise Africa or whatever you're using, you think if you're using it right now here in Uganda, you think that it is automatically protected either in Kenya, Rwanda, US, EU, or whatever country. That's what you all presume, that nobody else can come up with this similar name or similar logo or similar symbol, That's what most people presume. But no, it is not like that. Trademarks, like all other kinds of IP, are territorial, but it only applies in the country where you are until you take another step to protect that thing, to protect that trademark in another country. So you always presume that, since I'm here as Menterprise Africa, no one in Kenya is going to come up with Menterprise Africa. No one in Rwanda is going to come up with Menterprise Africa, with the same logo and, whatever trademark you're using. That's the common presumption. Then another common challenge is you fail to maintain or monitor. This again relates to the previous point. that when you register here your trademark, or when you come up with the trademark here, you fail to, monitor exactly what is happening in Kenya with a similar trademark. You fail to monitor what is in Rwanda, what is in Burundi, what is in any other country as regards to what your company name and trademark are. You are negligent. The other challenge is that, I will take an example again of maybe we have founders here, tech innovation founders here, but you are employing someone. Maybe that the real person, the real employee who is innovating. So you tell them to come up with a what? With a trademark for your what? For your business. But again, because you've not taken time or you've not been vigilant to define who is the real owner of this trademark that this employee has created, it brings about disputes. Why? You have not defined in the employment contract whether someone, the employee who has created a particular trademark, will be the owner or you'll be the owner. At the end of the day, they're capable of selling that trademark to someone else. They're capable of moving out with it because you never defined very well your employment terms. So it also leads to disputes. Then another thing is there are different kinds of trademarks, classes, trademark classes. There are products and services in trademarks, but there are different classes in which the different kinds of trademarks are registered or they're protected. So because you're looking at one thing, you miss out the remaining kinds of trademarks. That means someone else can come and register that particular kind of mark in a different class, and you're not going to be able to claim. So you are negligent about exploring the different classes of trademarks. The other challenge is, for example, now you've started your business, you've come up with a trademark, but since you have not yet, reached that step, that level of, I don't know how they call it in startups, but you are still testing your product. You want to see whether the market will work out or not. Will it sell? Will it do what? But you only have the company name. You have a trademark, something you've created as a trademark, but it is not protected. So most of the time, Uganda or most countries work on a first come, first serve. Now, your friend, a colleague, a fellow tech innovator, may have come to know about your trademark. As for you, you're still thinking about how your business is going to, be embraced by the public, by the consumers, and what have you. Someone else registers it as a trademark. Now, because Uganda works on a first come, first serve basis, most of the time, that person who came later on to register that trademark, even if you've been using it, they're going to take that trademark away from you. So that is also something you always ignore when you're starting what? Your businesses. Yeah. Would you protect a trademark, or is it mandatory to register a trademark? It's not mandatory, but it is highly recommended for purposes of, proving infringement. Of course, the trademarks that have existed without being registered, they have acquired something called the well-known, trademarks, well-known marks. But for them, they require a different kind of proof in case someone has, used it without your permission. But in the current regime, in the current legal world, it's very important for someone to register their trademark for purposes of what? Of proving that indeed they are the rightful owner. Then what are the benefits of registering or protecting your trademark? You have exclusive right over the trademark or ownership. Then brand credibility and trust. Now, for example, you all admire iPhones, There is some particular value attached to an iPhone. Or maybe I would ask which kind of product that you guys admire, whether it is a smearing oil, whether it is maybe juice, whether it is, KFC, whether, I may not be using typical examples in tech, but I just want you to know that there are certain, there are certain brands, there are certain trademarks which speak credibility and trust. They have attained that by consumers, that whenever someone just says, just sees, an iPhone or a Samsung, just sees a Mukwano product, they believe that, this is, a product worth buying. Then also, its protection enhances compensation. For example, in cases of infringement. Now, like I told you that there are certain trademarks that have acquired a well-known trademark status because they have existed, but they have not yet been registered or protected under the law, but they do exist. But now, assuming that there is someone who, like I gave an example of, you have a trademark, you have your company, but you have not yet registered it. But you have customers, who are now used of your brand, like they like you and what have you, but someone else has come up with that same trademark and registered it, and now customers are flowing to them because of that kind of trademark, because it speaks to you. Now, the challenge is when you do not register, remember, court is going to be, like not so convinced, or not so, or confused about whether indeed you are the rightful owner of the trademark or not. So it's, I don't know how, I wouldn't tell exactly how they would handle it, because there is someone who has infringed on the trademark, and then there is you who is claiming that you're the owner of the trademark, but it is not in your name. So I think you see the confusion about should they really, compensate you. So when you register it, there is easier compensation because it is in your name. You're the rightful owner. They will compensate you. Then, when you also register a trademark, it is a deterrent. So a warning to the public that, what? This trademark is, in case, if it's written on like, R, in case someone wants to register that same trademark, let us say, for example, assuming like Menterprise Africa was maybe that water product, and someone wants to register that logo of Menterprise Africa with that same logo and what have you, automatically they're going to find it in the registered URS base. What? This one is taken. But when you're not, everything is left bare. That is no warning to the public. And the other thing is that when you register your trademark or when you protect your trademark, it gives you like, the exclusive right I gave, the exclusive example I gave you, like the ownership example, and it also becomes a basis for international protection. That when you register something here, it is easier for you to carry it to another country. And you register it in what? In a foreign country. But when you have not registered here and then you just want to jump to Rwanda or Nigeria, really does not make sense. Yet you're doing your business here. That no product should enter Uganda or a particular country where your trademark is registered for any product with a similar trademark which is not from you. It is possible they can take down those products online, or they can also, like, how do they call it at the customs? No, like, like taking those products, like, I don't know how I should say it, impounding. It is called impounding or something like that. Like they impound the products and then they are not sold anywhere in market. Because the moment they bring that product in and then they start selling it in whatever with yours, there's going to be like competition over the customers. Whereby most of the time those infringing products are very cheap. They're going to kill your market automatically. So when you register something, it automatically gives you a right, to destroy or to, impound all the other infringing product that can come in that name or that trademark. Also, like I talked about credibility and trust, trademarks also speak to asset value and investment. In the current world, of course, it has not yet been embraced in Uganda, but there are certain brands that speak, of value that people can invest in. For example, the brand I know about most here in Uganda is Mukwano. Mukwano is a very big company. So investors, because of the brand they've built, because of, their business, their trademark, a lot speaks to investors, So they try to invest. And in the current world, like I said, Uganda has not yet embraced it, but it is possible for people to get loans over their trademarks or to easily commercialize their trademarks. Yeah, there are people who admire because of a certain what? Because of a certain company or because of a certain business. They will come to you, they will want to use your name because of the kind of credibility, trust, brand value you have built, you have created. So they want to associate with you. They may not necessarily do something that you're doing, but because of, the branding, the credibility, they will do their own business, but in your name. Franchising. Yeah, it is franchising, but it is a little bit different from that. Yeah. Someone can say that, let me do what? Let me start selling maybe these interior things, but in your name. Like that. But one thing I know about franchise is that it is something similar. You must do something extremely similar to the original founder or the original business, that you cannot sell something typically different. But you've seen like Mukwano. Mukwano is doing very many products, right? Yeah. So someone can say that, since Mukwano is in smearing oil, since Mukwano is in cooking oil and what, let me come up with some other name, but in the name of what? Mukwano. Unlike franchises where you have to do the same thing, exact same thing.
Doesn't that come with disadvantages like diluting the brand?
No, as long as I think, most of the time, as long as that person is making the money and you're not making, you're meeting their standards and they're not making losses, it doesn't. They know how to consider. Yes, there are considerations for everything. Trust me, because there is no business person who's just going to hand over their business reckless to you and then you start making losses and what have you over them. There are things that they consider most of the time. But I've not seen that something similar like that in Uganda. I'm merely giving examples. But I'm sure that people who are doing such things informally. You get it? I'm sure there is someone, like you've seen in Zambia, those guys who make furniture and what have you. I'm sure that people who are doing businesses there, but they're not the original, but there is a way they're affiliated, or they want to be, affiliated with those guys that in Zambia. Unlike franchises, which is, very strict. Yeah. So, what are the effects or what are the disadvantages of not registering your what? Of not registering your trademark. First of all, if you don't register your trademark, who are you? Honestly. Because the people will know that, your customers will know that, this is Menterprise Africa. But what is your brand? Because most of the time, the trademark is your brand. So who are you if you don't have a what? A trademark. Then most of the time, if you have a trademark but it is not registered, like I said, someone is going to come up with that what? Is going to end up registering that trademark that you're using or you're purporting that it is your trademark. Then at the end of the day, because of confusion, you are going to lose customers. Automatically, you're going to lose the revenue of the business. Then you're going to have to, litigate over who is the rightful owner. And all that is time-consuming, consumes your money, consumes everything. And then at last, most of the time, since someone else has registered that trademark that you are purporting it is yours, it is possible that court is going to rule that, you know what, you no longer, you who came up with that trademark, you will no longer be required to use it. Why? Someone else has registered it. They're now the rightful owner. And if you now want to still use it, trust me, you're going to be required to pay that person who has now what? Registered. For you to be able to again use what? His trademark. You came up with the idea, you never utilized it, someone protected it, they have now refused you from using the trademark, and the only way you can use it is by paying the infringer. Then, like, obviously, if you have not registered a trademark, there is no exclusivity, like you do not own it. Anyone is going to use it and they will become the rightful owner. So basically, the company name or your business name is proof you exist, but the trademark proves your brand, your value, and identity. I will still give an example of Mukwano Group of Industries. It has established a brand, it has value, and someone by merely, just looking at a product or using it, they'll, just know this is Mukwano. Yeah. Then we will go to another aspect of IP that is, used by tech innovators. It's called patents. Patents, I've had very many people in the public, especially Vanange musicians, calling copyrights patents. They say, I have a patent over what? My song. But what? Songs, the most applicable IP, or the applicable IP is called the copyright, not patents. Because patents, most of the time, or patents are a title. When you innovate something that is new, you do not have a right over it until government grants you a right over it, or an authority grants you a right over it. So when you may be like, because I know we may be having people here who are innovating in, not necessarily tech, but they're innovating maybe in the agriculture sector, health sector, and what have you. You may be coming up with new things, that try to, advance or ease in the everyday life of what? Of the public. But when you innovate that thing, however new it is, you do not have a right over it until government gives you, grants you a right over it. So a patent is a right granted by government to an applicant exclusive. There are standards it has to meet under the law. Yeah, there are standards like we have like some things like subject matter. There are things that are protected or that are supposed to amount to patents in case they're innovative. Not everything that you create or you come up which is new amounts to a patent, no. Secondly, what you're innovating must be new for you to have a patent over it. Then it must undergo what is called an inventive step. It is the most technical, and it is what determines whether actually they can grant you a patent over your product that you have innovated or not. Then whatever you've created must be capable of being used by the public. You're not just going to come up with something new you create. Yes, it is new. Yes, it has undergone an innovative. You've really proved that, there is a technical advancement, there is this and this. But when it cannot be used by anybody, that is not a patent. Yes. So whatever you innovate must be capable of being used. So most of the time, in tech innovation, your product your invention might be a process or a product. I could give you examples of what? Of product patents. For example, maybe banning microphone. Please don't laugh. But iPhones have a particular kind of tech. Like for example, the smartphone, the sensors, the screen guard, the biometrics, the fingerprints, all those. Not everything, because it must be new, because there might be a kind of fingerprint sensor that was there in 2000, which is not existing now. So whoever attempts to make a new, what do they call it? The fingerprint sensor, for them to obtain what they call a patent, there must be some technical advancement in it for them to be granted. There is a Chinese lady. She's Chinese, she's Japanese. She owns the patent to the iPhone, the sensors. She owns it. And every time an iPhone is made, she has to be paid for every innovation, because she's the owner of the patent of that kind of product. And of course, very many people have patents over only that one phone, because that one phone has very many patents, but people do not know. You think only the phone as a whole is, one kind of innovation. No, there are different kinds of innovations in one phone. which may be patents, which may be copyrights, which may be trade secrets, which may be anything, but in just one product you're holding. Then what are the common patent pitfalls among tech innovators? For example, the challenges or the things that you guys ignore when you're trying to, innovate something that can be patented. The first point is premature public disclosure. Again, I'm going to refer to the hub. You guys are very many here who are tech innovators or, involved in startup work. It is possible that when you're trying to innovate something, you are going to disclose it to your colleague who is also a founder here at the hub. It is possible that you may disclose it to a founder, a possible founder, or a partner, or an investor, however you may choose to call them, or you may even, talk about it on social media. It is wrong because it dilutes the whole process. Or most of the time it is possible. That person that you have told, like I told you, IP does not protect ideas. You're not going to sit and then you discuss with another tech founder that, what, there's this particular thing I want to do, I'm going to do it like this, it is going to solve such a matter. You have not yet created it, you have not yet, innovated it, you have not even protected it by registering, but you're telling everyone what you're planning to do. Now, in patents, it is not allowed. So that is one challenge. Then two, you do not again do a comprehensive search. Most tech founders are literally like, I'm sorry if I'm going to say it the wrong way, but you're 24/7 you're innovating the same things or something that is exactly or similar, like something that is already on market. There is no creativity, there is no innovation. You don't search and say that, what is missing maybe in a particular sector? What can I add on it? No, you just create. You just innovate. Why? You've either not searched or you're innovating because there's a particular product you admire and you want yours to be like that. So you fail to conduct searches. You fail to add on, like, you fail to add value or to show any technical advancement to whatever you're creating. Like, whatever you're creating is already existing. But, okay, whatever you're creating, that new product you're creating, how different, how advanced is it to the previous product or the product that is already on market? So you fail to do that. You just create for the sake that, even this one can work in health. Even this one can work in education. Even this one can work, such things. But there's literally nothing new that you're creating. And there's nothing it contributes to what? To the innovation sector at the end of the day. Then, the other challenge is that, for example, okay, we said that now you've innovated, You've created something that can be patented. Because like I told you, you cannot obtain a patent over any product until government tests it and says that, it is worth being a patent. There is a technical way of drafting the claim. Now, you just draft it, you just say, this thing, if used, it can, it can work on, it can work like this, It does this and this and this. But, when you're drafting a patent claim, patents, not every lawyer, not every IP person draft patents. So you have to get someone in the, in that kind of, with that kind of expertise to help you draft a patent claim. For example, is someone I profiled at IP Aware Africa. So the experts, not everyone, not every lawyer, not every IP person is going to be able to draft a patent claim. So you have to get an expert. So that you don't, present narrow things to the registrar. Because at the end of the day, when you draft narrow things, someone is going to now come and, try to patent around what you've already claimed. And for them, they will take that. Yet, even your product can do exactly what they're trying to claim in their patent. And then, when you're applying for a patent, you don't provide enough information. Like I told you, when you're claiming a patent, when you're claiming, a patent in that claim that you've innovated, you provide everything. Whether the pictures of what you've innovated, how it works, how it reacts, whatever knowledge, the kind of knowledge it is advancing, everything connected to that product, you name it. But so when you fail to provide enough information in the application to the registrar, trust me, that means that because when you provide that information, they're going to try and carry out that patent, that product that that you have innovated. So when you fail to provide enough information so that they can be able to test whether what you have provided works as that particular product, they're going to reject the claim. Yeah. Then the other thing is that, okay, I'll take again an example of, we don't have very many people with patents in Uganda. I'm sure we do not have more than 10 people. But I beg to be corrected. I'm sure we do not have more than 10 people in Uganda with with patents. But most of the time when you innovate or you create something, you sit with it again here in Uganda. Like trademarks, you think that you're protected because you created a particular product. Now they've given you a patent, you feel like you're very safe. You're not safe. A person can come up with that very particular product and and register it in Morocco as their patent. Someone can protect that very product in Europe. Someone can protect that very product in Australia or the USA. So it is very important for you to explore the international markets when you're dealing with anything to do with creativity and innovation, so that you're protected internationally and your product is not replicated. Then again, once again, just like the trademarks, again it could be like an employer-employee. The employee is maybe like mandated, to innovate or to create particular products. They have created an invention, but in your employment contract, again, you have not defined who is going to be the owner of the patent, of the invention in case it is created. You have not defined who is going to, like how the both of you are going to benefit. But of course, most of the time there is a way the law considers in case such agreements are not in existence. But it's very important most of the time that you define for yourselves, like, when you create a certain product, it's me, the employer, who is going to be the owner. I'm going to owe you such and such an amount, so that you don't go into legal disputes of who is owning and what have you. Yeah, for example, in Africa, we have ARIPO, African Regional Intellectual Property Authority, or African Regional Intellectual Property Organization. That most of the time, for example, if you're applying for a trademark, to register a trademark or a patent, you could just file one application and you'd be covered in all the member states of ARIPO. It is URSB which will remove the application. But because of just one application, since you've applied for regional protection, it will be moved, or it will cover all ARIPO member states. Or sometimes you could even file a global one URSB, through URSB, but it extends to all members of the World Intellectual Property Organization. So it covers you at once, without you saying that, let me go to Kenya. But as long as Kenya is a member state of either ARIPO or WIPO, the moment that application is targeted at one of those organizations or one of those regions, you are automatically protected. So in cases of infringement, you are free to go against that person in that member state who is misusing your trademark or patent. For patent, it is mandatory because, like I said, when you create or innovate something related to patents, or if it is a patent, trust me, you will not have a right over it until government grants you that right. specifically for patents. You do not have a right over it until the government authority or an office mandated with such what? Function to give you that, you know what? He has innovated a drug. He's now the owner. But if you just create the drug and then you sit with it there and then you're like, oh, this is mine, I can sell. Trust me, you're even going to be arrested. Because most of the time, patents are solutions. So they're supposed to be tested to see whether they can, be applicable to the public, they can be used by someone or not, So there must be that testing, that standard it has to meet before they can give you ownership over it. So it is mandatory for you to register or protect a patent. If you do not, it is not yours. What are the benefits of protecting patents? Legal protection, like I said. Like you have exclusive ownership over it. You are able to monetize it or commercialize it. You can be able to license the franchising you talked about. You can be able to franchise it. You are able to use it as collateral, though it is not yet applicable in Uganda. I don't know who has used their patent to obtain a loan in Uganda. I've not heard of any. But one thing I know is that in those other countries, you are able to what? To use a patent as collateral for loans. Then you can also attract investment. I wouldn't want to use the example of Covidex. Yeah, because it's not a patent, but it's an innovation. Yes.
What failed it from being registered as a patent?
It did not meet that step of, that standard of inventive step. There was nothing, like new or a technical advancement to it. Like I think when they tested, the officers tested, there was something similar already existing on market. Yes. Then also the enhanced business value, like your registration, you are the rightful owner, there is something, there is some value attached, to your product. So there is value attached to it. It is worth, like you have mentioned, the Starlinks, they do work. So people know that, they are valuable. So then it also encourages innovation, leading to technical progress in the field. Like I said, patents are granted for a particular period of what? Of time. So after that time, it is possible or it is presumed that someone else, or even you yourself, you could be able to make some advancement on it to allow people to advance so that they can be able to cater for another problem. Yes. Then I talked about the brand credibility and trust. It attracts strategic partnerships. You heard of Covidex, where many people came in, but I don't know how far it went. Literally, it's like you have monopoly over the market. You get everything that you invested in it back. So that is one of the importances of registering your patent. I think we can have a break from here before we go to the trade secret.